or a writ petition has been listed before Lordship, one connected I is there that may be listed along with.
Maybe Lordship. Item number 36 and 37, my lord. I need to file, my lord, evidently in reply in respect of evident objection filed by
36, 37.
my lord. 3 weeks, my lord.
Okay. Mr. H.R. Amit, learned counsel for the petitioner, has sought for and is granted 3 weeks time to file an affidavit in reply to the affidavit in opposition filed by
Respond number 3, my lord.
Respond number 3.
Obligement.
Release the case after 3 weeks on a date to be expired of this. Same 37 petitioners. Okay, Mr. Smith. Mr. Who is there? PKMT, Learned Junior Government Advocate. Aforesaid revenue are presently scheduled.
Obligement.
May I please, your lordship. My lord, for item 28, my lord. My lord, I may be allowed some time, my lord.
You are for respond number 5
Respond number 5, my lord.
to file affidavit.
Yes, your lordship.
Okay.
I'm for the petitioner, lordship.
3 weeks, my
Mr. U.S. Bora, learned counsel for the petitioners, and Mr. PKMT, learned state counsel are present. Mr. M. Islam, learned counsel for the response revenue schedule. Learned counsel for the response number 5 has sought for how much time you need?
no, 3 weeks, my lord.
It's granted 3 weeks time to file an affidavit in
Lordship, interim is there.
opposition on behalf of the respondent number 5. Is the case after 3 weeks on a date to be expired office. The interim order passed earlier shall continue till the next date of listing.
Highly obliged, your lordship.
May it please, lordship. Lordship, I beg to mention item number 44. I have taken consent from
44
You have to mention before another court.
lordship.
Listing of a matter for withdrawal, lordship.
May I please, lordship. Lordship, item number 24, my lord. Kindly adjourn this matter for today, my lord. 24.
On the request of Mr.
Yes, Ahmed.
H. Ahmed, learned counsel for the petitioners, the case is passed for the day. Mr. P.K. Medi, learned junior government advocate for the state respondent, and Mr. A. Authorised, I got to you. Number to 5 are present.
Obliged. May I please, lord. Lord, may I pray for listing of a IA, my lord? Any day before 28th of August, my lord. For implement of parties, my lord.
Give it to the court.
My lord.
May I please, your lordship? I am appearing on behalf of my senior counsel, Mr. D.K. Bakshi, for the petitioner in the instant case of contempt petition number 720 of 2024. Your Honor, we have filed a mention memo for the due to an urgency of pleadings committed. So, subject to your convenience, we request
Oh,
to find it this
mention memo.
Friday.
So please give it to the court master.
My please, your lordship, with the consent of the other side, I beg to mention item 40. We'll be filing a counter.
40 you have to mention before another court.
May it please, your lordship. Lordship, I am praying for withdrawal of item number 14. Lordship, in this matter, the GST notice that was issued proposing the cancellation that has been revoked. So,
Mr.
P. Jalan on behalf of A. Goyal.
Mr. P. Jalan, learned counsel on behalf of Mr. A. Goyal, learned counsel for the petition has submitted that since the cancellation of GST registration has been revoked from the petition, in the meantime, the petitioner is not pressing this petition. In view of the above submission made by Mr. So-and-so, learned counsel for the petitioner, the petition is disposed, is dismissed as not pressed.
Lord, I am for the respondent number 3 in this case.
Okay, Mr. S. Setia, learned senior standing counsel, income tax.
Lordship, CGS.
CG,
ST, lordship.
Okay,
Respondent
for the
number 4.
respondent number 3. is
4,
present.
my lord. I'm
Is
sorry.
presently scheduled. Officer in view of some.
My lord, may I please, your lordship, my lord, I like to mention item number 5 and 6, my lord. In those cases, my lord, we supposed to file, my lord, supposed to get the instructions, my lord. However, my lord, I am paying a further 1 week time, my lord.
Okay,
No objection.
Mr.
P. Jalan.
P. Jalan, learned counsel on behalf of Mr. A. Goyal is present. For the petitioner is present, huh? Mr. S. Setia, learned senior standing counsel, income tax
Lordship.
has sort of, what is the issue?
Regarding, my lord, they are claiming exemption, my lord, under well.
Sound 5 and 6.
And they filed a rectification petition before the authority, my lord.
Okay. Has sought for further 1 week's time to obtain instruction as regards the status of the rectification application.
Lodge.
First off, as sought for by Mr. Chettiar, list the case on students.
2808.
Same, deeply obliged. 6.
Obliged.
Any other request?
My please, Your Worship, I beg to mention item 55 of the supplementary list, my lord. Our instructions are awaited. I'm praying for 2 weeks' time, my lord. Date may be fixed, my lord.
55, why it has come?
My lord, there was a ad valorem duty, my lord, which was imposed upon
No,
the
orders, or in the orders column? Have you checked? Heard Mr. M. Sharma, learned counsel for the petitioner, and Mr. I. Bodhakur, learned 55.
55.
Learned standing counsel, excise department for the respondent number 1 to 6, and Mr. P.K. Medi, learned junior government advocate Assam for the respondent number 7 to 9. Post. Mr. Bodhakur has sought for and is granted how much time?
2 weeks, my lord.
2 weeks time to file an affidavit on behalf of the respondent excise department. Post of. Peruse the office note dated 18/8/2026. Post of. The matter be placed, in the meantime, before the Rajima Court for a report as regards service of notice upon the respondent number
10.
10. Then 1 to 6, 7 to 9. Okay, 10. And to place the same before the to place the same for a report as okay, place the same.
Obliged.
Any interim order? The interim order, if any, past idea shall continue till the next.
Daily list for motion, item 1.
Badly. On contempt application, my lord, there is a decision for, my lord, for granting, my lord, sale permission. My lord, the issue is, my lord, regarding grant of composite. There is a decision for, my lord, granting sale permission regarding land, my lord. And that decision has not been, my lord, complied with, my lord. Lordship will find that order, my lord, page number 9 and the relevant portion, the last page, my lord, of the order. Lordship will find page number 13, para 10, my lord. As it is open for the petitioner to file an application after this writ petition is disposed of, permitting the petitioner to submit a fresh application.
Mr. M. A. Islam,
My lord.
learned counsel for the petitioner. This contempt petition is filed alleging non-compliance the direction made in an order dated 25/5/2026. Passed in a petition WBC number 142/2026. Post of. The petition was disposed of, permitting the petitioner to submit a fresh application along with all the requisite documents. And in the event such application is filed, the respondent authorities who were directed to process the application strictly in terms of the provisions of the Assam Right to Public Services Act, 2012 as amended, and 2012, and a notification dated 11/11/2022 of the Revenue and Disaster Management Department, Government of Assam. The petitioner has averred that after the order dated 25/5/2026, the petitioner submitted an application on 4/3/2026. Post of. It is stated that the state application has not been processed and for delivery of the notified public service, composite land sale transfer till date. Issue notice returnable in 4 weeks. steps upon the respondent number. Steps upon the respondents. Petitioner shall take steps, huh? Speed first, within 2 working days.
All right.
Item 2.
All right.
Is your lordship. My lord, relevant paragraph is at 16, my lord. This order passed by this honorable court, my lord. Matter is page 16, last paragraph.
Third, Miss P. Goswami, learned counsel for the petitioner. So this contempt petition is filed alleging non-compliance of the direction made in a judgment and order dated 2/12/2025. Passed in a writ petition WBC number 3877/2021. It is averred that the notice of the respondent. Issue notice returnable in 4 weeks. The petitioner shall take steps for service of notice upon the respondents by speed post within 2 working days.
God bless me.
Item 3.
The last occasion instruction was sought for.
Lordship, I require 2 weeks more time to take instruction whether the amount of 81,900 has been refunded back to the petitioner or not.
July, June, July, August. Then we'll issue notice. Third, Miss S.S. Jia, learned counsel for the petitioner, and Mr. K. Jain, learned counsel on behalf of Mr. S.C. Cap,
Lordship,
learned senior counsel and special counsel
Lordship, for the
Customs Department
Customs Department.
for the respondent number 1 and 2. First of, the petitioner has approached this court stating that the respondent authorities have not yet refunded an amount of rupees 81,900, which amount the petitioner deposited as security deposit in connection with seizure of a consignment. Issue notice returnable on so and so. As Mr. Joint has appeared and accepted notice on behalf of both the respondents. Issuance of formal notice to the respondent is dispensed with. However, the learned counsel for the petitioner shall furnish the writ petition along with annexer to Mr. K. Jain within 2 working days from today. So it is observed that pendency of the writ petition shall not be a bar for the respondents to consider the grievance raised by the petitioner in accordance with law.
Lordship.
My
Much
lord, date fixed.
25th September 2509.
You hear?
Item 4.
There was instruction is awaited.
Still awaited.
Lordship.
Which district?
Kamrup Metro.
Kamrup Metro.
Kamrup Metro.
And this, that particular circle always has a problem. This would.
I have seen in the newspaper with this shifting offices. a
They
new
have
office-
shifted it.
Huh?
Yeah.
A new office is being inaugurated today. Is it?
Yes.
I have seen a
No.
big one-page advertisement. I don't
One
know.
piece advertisement.
Okay, I will give you one more time, then otherwise we'll issue notice.
For means
How
for-
much time?
For 26 years.
Right, but we are keeping it at a motion stage
Means,
to expedite your grievance.
yes, sir.
redressal, but otherwise you have to issue notice
Yes.
with one more time.
Lordship.
I heard Mr. A. Biswas, learned counsel for the petitioner. A. Bhattacharya, Revenue 1, Mr. P.K. Mehdi, learned junior government advocate Assam for the respondent number 2 and 3. Post of Mr. Mehdi, learned junior government advocate has submitted that he has not yet received instruction as regards the status of case number so and so from the respondent number 3 and has sought for further 10 days time. 10 days time
First week of
to,
September.
to obtain instruction regarding the present status of case number swings. List the case accordingly on swings.
2nd September. 0 to 0.
Oblige, Your Lord.
Item 7. This regarding sealing of this business premises, my lord, the instructions were sought for. Our case is that there is no resistance at the time of entrance in the premises, therefore sealing is not permissible, my lord.
Lordship, here I require 1 week more time. I have not. Your documents itself
Yes, lordship.
indicate that
There was no
entry was peaceful.
my lord.
There was no resistance. Then the sealing is against the statutory provision.
Yes, sir.
And
on the basis of the notice. Even my lord, there is no order for sealing also, because order of prohibition does not say to seal the premises.
photograph says,
You know, that's why, my lord, without order, they pasted, my lord. They say prohibition order, but prohibition order does not speak of sealing, my lord.
Not see here situation is. I'm sorry.
so what more time? Otherwise, you will pass the final order.
Lordship next Wednesday.
Because your document says,
Yes, lordship.
so it goes by Mohinder Singh Gill.
Lordship, it's.
So it's not order, act. Your act itself shows. Now you cannot improve your situation.
That's right, lordship.
Okay, RS Mishra, petitioner, B. Chaudhary, standing as finance 1, 3, 4, 5, 6. And Mr. R. Sharma and CGC for respond number 7. Who is 2? Sorry, 2. R. Sharma. Mr. Chaudhary. I'm told that there is already a judgment.
Yes, ma'am. I just got.
Let me read it in the meantime.
Yes, madam. Lordship, I repeat. My friend has appeared here, ma'am.
Okay. Till
26.
8, 2026. To obtain instruction in the matter as sought for by Mr. Chaudhary is the case on 26.
Much obliged.
Item 8.
For this one, this I have not read. I did not get time, Mr.
Lordship, but next week, Lordship.
I have to read.
My lord, next week.
Keep another copy. I'll take it out from the file so that I can read. Otherwise, file goes back.
Lots.
I've given this in the email, my lord. I will give hard copy also. I have this hard copy also.
I'll keep it.
My lord.
Just for. Okay.
Lots.
I have also provided to my senior friend also.
What's the issue here?
My lord, regarding my lord, freezing of the
Electronic
credit ledger, my lord.
credit ledger.
Yes, any instruction, Mr. Carl?
Lordship, here the situation is different. Final order has been passed. And Lordship, he has taken ITC, which is not, he is not eligible for. That's why Lordship, this is a difference from other cases. Lordship. If it's during the interim period, then Lordship 86 capital A 3 will be applicable.
If all respondents are represented, we can issue
Lots.
notice then.
My lord, there should not be interim, there should not be coercive action because, my lord, because of this debit freezing of this ledger, my lord, I have not been able to make this.
Oh,
It is a
okay,
difficulty.
okay. Let me read then.
My lord,
We put it on the next week.
my lord.
Same, so I got to repeat. 26.
6, my lord. Deeply okay.
Thank you.
Item 9. This is, my lord, that freezing of bank account, my lord. Beyond 1 year, my lord.
Okay, yes, yes.
DRC 22. That was issued Lordship in all the cases.
This petitioner is involved.
Lordship, notice has been not issued, but Lordship on last occasion asked me to whether DRC 22 has been issued. Lordship, as per Act,
It is a
the
case.
bank is required to open the bank account within a year, not in the investigation.
I've got the judgment of effect.
Just
for
a
my-
minute.
Sorry.
Radha.
No, my lord, my lord, Kesri Nandan mobile, it says, my lord, even after expiry of 1 year, they cannot renew also, my lord.
The petitioner savings bank and maintained at so and so. Has been kept locked since so and so, without serving any home. As required under. The proceeding was initiated under. Right. How long it will sustain this DRC 22?
Only for a year. Section 83(2) says that every such provisional attachment shall cease to have effect after expiry of period of 1 year from the date of the order made under subsection 1. Lordship, I have made inquiry specific note from the department. They have not issued any letter to the bank. Bank is not de-sealing the account. Lordship may give a direction to the bank to
So other than this one, you don't have any. So even if it cannot be extended.
yes,
Is it
the
so?
the department does not issue any letter to the bank for extension of that.
Even, my lord, is form DRC 22, my lord. It itself says, my lord, after expiry, it elapsed, my lord. The form 22 itself, my lord.
Okay, I'll go through it Friday. Friday I'll pass the order.
All
My-
the item 8, 9, 10,
Huh.
9, 10, 11, 9, 10, 11,
How many?
9, 10, 11.
1911. Mr. R.S. Mishra, petitioner and C. Kyle, I would give. Air Chandra, Naboyal Giri, B. Chaudhary. Okay. So this the case Friday, huh? I sought for on Friday.
Lots.
2108.
এখন মনে করিব এখন ইয়াতে সোমাই থৈ দিব ফটোকে বুজি দিব এইটোৰ লগত এইটো এটা ওলাই থৈ দিব Same, huh? 890.
Item 12.
May it please your lordship. Lordship, the present writ petition has been preferred against the inaction of the respondent authorities in acting upon the complaint submitted by the petitioner, lordship. Despite the petitioner having approached the competent authority, the respondent authority has failed to conduct any inquiry or any reason decision has been communicated to the petitioner. Lordship, the case of the petitioner is
Yes,
that,
ma'am, your good name, please.
my lord, M. Sharma.
Heard Miss M. Sharma, Learned Counsel for the petition. Mr. Roy, you represent?
1, 2, and 4.
Okay. Mr. S. Roy, Learned Junior Government Advocate Assam, for the response number 1, 2, and 4. Alleging inaction on the part of the respondent authorities to act on the complaints submitted by the petitioner regarding functioning of the respondent number 5. Commander petition has preferred petition as senior citizen.
Yes, Honor.
A senior citizen has preferred this petition. Issue notice returnable on so and so as Mr. Roy 1, 2, and 4. Steps upon 3 and 5 by speed posted into working days.
2509, 25th September. Item 13.
Wait, please, your lordship. Lordship, this is another one of the similar case as we have annexed. Only difference being that this one was purchased from a Rayati who had acquired by operation of law under Section 4 of 1974 Act of the status of landholder, lordship. The only difference, the claim of inaction of respondent authorities in issuance of patta is same, your lordship. The petitioner prays for a similar order, your lordship.
You made a statement that Samsul Haq is one of the recorded tenant. What is his Khatian number?
Lordship, the Khatian is reflected in the sale deed, your lordship. Annexure to page number 15 is the translated copy, your lordship.
No, sale deed will not do.
Through the sale deed, the petitioner got
No, maybe wrong also, wrong statement also. How can we decide it?
lordship. Currently, the petitioner only has the sale deed, your lordship. He got the rights of Rayati transferred through it, your lordship.
By which provision he has the right to transfer?
Lordship, since all the zamindari estates, land under zamindari
By which
estates,
provision of that? By which provision of which act? Suppose assuming Samsul Haq is a Khatian holder. By which provision of which act? He has got the right to transfer.
lordship, the land under their ownership, they sold the land,
We will now simply issue notice.
lordship.
Heard Mr.
IS Mazhar Bhai.
Major Learned Counsel for the petition. Yes, Mr. Aforesaid Revenue 1, SS Roy 2, 3. The petitioner has preferred this writ petition, preferred this writ petition, seeking inter alia direction to the respondent authorities to issue regular bata to them in respect of a plot of land measuring 2 bighas, 2 lesas, covered by Dag number 51 at Village Surya Khata Park 3, Bilakipar Avenue Circle, District Hubli, Assam. Issue notice. Returnable in 4 weeks. As so and so appear accepted. No formal notice. Extra copies. Yes.
Much obliged, your lordship.
Item 15.
We take notification, my lord, pending before honorable effects court. Lordship has passed similar order. Lordships.
R.S. Mishra petitioner. Any union? Or you represent Mr. Jain, you represent union? S.S. Roy, Central Government Council. For the respondent number 1. K. Jain.
For 2 and 3 lordships.
Where is Mr. Chaudhary or Mr. Gogoi?
The order has been passed by the state GST lordship.
Where is Mr. Gogoi? Chaudhary. Name is reflected or not?
My lord, reflected.
Yes. Yes, हमारी तो वो B. Chaudhary लिखी हो. B. Chaudhary. 456.
Up to 7, my lord. 4, 5, 6, 7. Respondent 4, 5, 6, 7, my lord.
7 also.
7.
Okay, 7. Carries on the business of two-wheelers.
2 years.
And is a dealer of Hero Moto Corp. And is a registered SSC. It will change for you. Registered number. Who issued the summary show cause notice?
Respondent number 7, my lord.
Date
12/12/2023, my lord.
financial year.
18/19, my lord.
When is the order?
The order lordship 24, 22, 24, my lord, sorry, 22/4/2024, page 61.
Under 73.
My lord.
Demand.
My lord, this is for rupees, my lord. 1,02,37,514. Page 63, my lord. Or page 62 also. Much.
Page Borough, Learned Counsel on behalf of Mr. B. Gogol, Standing Counsel Finance and Taxation Department for the respondent of 4 to 7.
Item 16.
Made please, Your Lordship. This petition filed for seeking compensation causing the death of my husband, my lord. Now here, my lord, what happened, my lord? My husband was arrested and was charge sheeted under NDPS, the relevant NDPS Act, my lord. And thereafter, my lord, after the charge sheeted, I have applied for the bail, my lord. If Your Lordship may come to page 41.
Now, what relief you are seeking here?
My lord, the cause of my death of my husband, my lord, is because due to the negligence caused by the jail authorities. And I was not given proper medical health care. My husband was not given proper medical health care, my lord, during my time in the jail.
So, your
Lordship.
husband died in judicial custody.
My lord. When I saw
Allegedly due to lack of
my lord,
medical treatment.
My lord.
That is your case.
My lord. I sought for bail, my lord. The bail was denied, my lord, 3-4 times.
Oh, those are
My lord.
judicial orders. That is
My
not
lord.
the subject matter of our case.
Even, my lord,
We are not going into
my-
that
yes.
aspect. Denied means denied.
My lord.
You challenge
No, 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 I
before Supreme Court, before
no.
all the forum. That is not our
I agree.
concern. No judicial order is to be examined in a writ
No,
petition under Article
Sorry,
226.
my lord. Perhaps, that is my case when I was
Of this case, Lordship, he is claiming compensation, Lordship. But died in hospital, Lordship, not in judicial custody. He was given treatment, Lordship, thereafter he died. In hospital died, Lordship.
My lord, if Your Lordship will come to page 67, my lord, the orders. I was not been even able to appear before the trial court, my lord. From 67, my lord.
Page 70, Lordship. Is in YouTube PMCH stage 2 for better treatment as referred.
Hmm.
Don't fall, brother. Gosh.
Page 72 is
Have you brought this fact regarding his non-treatment before the
lower court.
court of competent jurisdiction? Because you were reported to be sick,
My lord.
right?
Yes.
That court had all the powers.
My lord.
That court had all the powers to take proper measure, to direct proper measure.
Lordship 71, 72.
My lord, if I
Page
may.
71, 72.
I'm just asking
My
you,
lord, my lord. But if
did
Your
you
Lord-
make any? Because all these orders does not,
My lord, Lordship
do
may
not
come,
show.
and if Your Lordship may come to page 62, my lord. From there it starts, my lord. Page
No. These are few dates.
My
Page
lord.
66 onwards.
My lord.
These are few dates. Oh,
62.
NBWA.
My lord.
Then you were brought.
Initially what happened, I was granted bail, my lord. And thereafter,
Then
my
you
lord,
jumped bail.
well, I could not, because of my health condition, because of my husband's health condition, I could not appear. And
No,
there are some,
who is the accused? Your husband is the accused.
my lord, my husband is there.
So he jumped bail.
Well, he jumped because he was unable to appear. My lord. Earlier dates, he was absent with steps. But later on, what happened, he was not able to contact the council. And thereafter,
That is-
my lord.
That ground is not palatable
My
to
lord,
this court.
definitely. If Your Lordship
That
come-
kind of ground is not palatable to this court, that
Right.
he could not contact his client. I have seen many, thousands already. such ground.
My lord. If your lordship, and thereafter, my lord, his father applied for the bail, which was also rejected, my lord.
Ultimately, he was arrested on the strength of NBWA. Defaulter. So it took about 1 year to execute the NBWA.
My lord.
10, 14, 11.
On 10, my lord, at page-
Reported to be sick.
on page 62, it's there.
What 62? 62 must be before 66.
No, yes, before 60.
Huh?
But from 24/9/2025, he's been reportedly sick and he was not produced before the court.
No, no, 62.
62, my lord. These are the orders. Accused so and so is not produced from judicial custody. He's reportedly to be sick from jail authority. 24/9/8/10.
1 minute. Please, what does
62, my lord.
66 says?
Must-
It says said accused defaulter in his appearance since 22/11/2024.
Man, he was already in judicial custody, my lord.
No, I'm trying to
My lord.
reconcile.
No.
Page 62,
My lord.
you say a date 24/9/2025.
My lord. He was. I was in the judicial custody. I was not.
Please explain me.
My lord.
Come to page 66 first.
Yes, my lord. This is the bail application.
There it is recorded.
My lord.
The accused is a defaulter in his appearance since 22/11/2024. Right?
22/11.
Right.
My lord.
Then, since then, the NBWs were being issued against him. Ultimately, he was arrested on the strength of NBWA. When? When?
My lord. Page 58, my lord.
Tell me the date.
My lord. 27/8, my lord. He was
27/8.
my bail petition was rejected and 10/9/25.
Huh?
My lord, page
Tell
50.
me properly.
My lord.
Page
Page 61, my lord.
Now tell me the date.
My lord, 27/8/2025.
27/8.
8, my lord.
Page
61.
So it was a period of 1.5 years without any step
Well, that was, yes,
before the court.
before that, but since 27/8/25, I'm in the judicial custody.
May 2023, November 2024. He was not present without
Step.
step before the court. Then thereafter,
NBW was.
up to 27/8/2025. Meaning thereby 2 years, 3 months. He was jumping bail, right? In August 2025,
I was arrested.
he was roped in. And when did he die?
13/12/20. Yes.
Heard Mr. M. Smith, learned counsel for the petition. Mr. S.S. Roy, learned junior government advocate Assam for the respondent number 1, 2, 3, 4, 5, 6, and Ms. S. Sharma, learned junior standing counsel, Health and Family Welfare Department for the respondent number 7 and 8. Post. The husband of the petitioner was arrested on the basis of an FIR registered on 15/10/2022, and thereafter, he was produced before the learned Chief Judicial Magistrate Sunitpur on 6/11/2022. Post. After investigation, a charge sheet was laid, and a case, special NDPS case number 21/2023 was registered before the learned special judge Sunitpur on 10/2/2023, and a charge under section 20 within bracket small b, within bracket small Roman 2, within bracket capital C of the NDPS Act was framed against the petition. First off, it is a case of the petitioner that her husband was suffering from chronic kidney illness, and at different point of time, he had to be admitted for treatment. First off, he was granted bail on medical grounds by the special court on 3/5/2023. First off, as the petitioner's husband did not appear in the trial during the period from 26/5/2023 till 22/11/2024 without taking any steps, the special court ordered issuance of NBWA against him. Post. The NBW was executed on 27/8/2025. And since then, he was in judicial custody. Post op. Para, the present petition is filed seeking compensation for the death of the petitioner's husband in judicial custody on 13/12/2025, contending that he died in judicial custody due to lack of proper medical care and treatment. Post op. Action against erring officials are also sought. Issue notice, returnable on 4 weeks. As so and so appeared accepted. No formalities, extra copies. 2 order.
17.
May it please your lordship. Lordship, this petition is in matter of inaction of the part of on part of respondent number 2 in respect of registration of a case, your lordship, regarding allegations made in the FIR. FIR is annexed in annexure number 5, page 20, your lordship. Your lordship, the background of the matter is that the Lanka Municipal Board had earlier awarded work order to one Chabi Tapada.
Whatever. Have you approached the SP?
FIR was sent to them through registered post, your lordship.
You act on a registered post. Then thereafter, have you approached the jurisdictional magistrate?
Lordship, an RTI was filed.
Have you approached, yes or no? You file RTI before judicial magistrate?
Lordship, no. RTI was filed.
What is the law?
Lordship, RTI was filed to the SP to seeking
SP.
information on the.
If you are not provided information by the SP.
That I have to take instruction, by.
What? This is to be dismissed.
That.
This is to be
not
dismissed in limine.
That was there for RTI.
RTI, we don't know. What this kind of petition? Some NIT, something, then file and complain under section 173(4) read with section 175(3). Why you are coming that mandamus for registration, directly registration? This is the case. Yes. Heard Mr. I.S. Major Bhuya Learned Counsel for the petition. Since 2008, law is settled. Don't come with this kind of petition before this court. And Mr. S.S. Roy, Learned Junior Government Advocate, Assam, for all the respondents. First of all. The case of the petitioner is that Lanka Municipal Board, Command District Hojai, Assam, invited quotations from intending suppliers for supply of sand gravels, provide a tender notice, NIT number so and so, para 2, dated 18/5/2022. First of all. In response to the tender notice, the petitioner submitted his tender, quoting a rate rupees 925 per cubic meter of sand gravel. And the petitioner has claimed that the rate quoted by him was the lowest rate. First of. The date of opening of the tender box was 26/5/2022. First. The petitioner stated that the municipal board prepared a comparative statement and according to which the lowest quoted rate was rupees 925. But the municipal board allowed the tender of one Chobi Toparar at a higher rate of rupees 1,250. The petitioner has claimed that the beneficiary bidder did not file the tax clearance certificate along with the tender documents. And obtained and submitted the tax clearance certificate on 27/5/2022. That is long after the date of submission of the tender documents. First, para with such allegations, the petitioner lodged. Why you have come earlier?
Lordship, we had filed regarding the misappropriation, and we were given the liberty, Your Lordship, to take recourse to appropriate provisions of law, and therefore, after that, we have pursuant to that, we have filed the FIR, Your Lordship. And now the inaction on the FIR
The
has.
petitioner had earlier approached this court by a writ petition. WPC number 1332/2025. And the said writ petition was disposed of by dismissed by an order dated 15/9/2025. First off. In the writ petition, the petitioner had sought for a criminal investigation as regards the tender process initiated by, as regards the alleged irregularities committed by the Lanka Municipal Board during the tender process, aforementioned tender process. First off. As the petitioner, before approaching this court by the writ petition, did not file any FIR. The court, the Korean bench, while holding that while dismissing the writ petition, had observed that the question of issuance of any direction for a criminal investigation was not warranted. So liberty was, however, granted to the petitioner to take recourse to the appropriate provisions of law, if so advised. First of there, after dismissal of the writ petition, the petitioner has stated that after dismissal of the writ petition, the petitioner sent a first information report on 18/9/2025 to the officer in charge, Lanka Police Station, via the registered post. It is stated that the officer in charge, Lanka Police Station, did not register the FIR. Thereafter, the petitioner submitted an application under the Right to Information Act on 23/6/2026 before the Superintendent of Police, Ojai, seeking information regarding the aforementioned FIR, but no information has been furnished to the petitioner till date. With the above projection, the petitioner has instituted the present writ petition on the article seeking under Article 226 of the Constitution, seeking invocation of the extraordinary jurisdiction of this court for a direction to the respondent authorities to register and investigate the case on the basis of the FIR lodged by him or her,
Lordship, him.
or lodged, sent by him to the officer in charge, Lanka Police Station on 18/9/2025. Full stop. Mr. Roy Lane Junior Government Advocate, Assam, appearing for a state respondent, has submitted that in the event the affair, stated to have been sent by the petitioner, disclosing commission of any cognizable offense, has not been registered by the officer in charge of the jurisdictional police station, and also by the superintendent of police, jurisdictional superintendent of police, or if no action has been taken on the basis of any application submitted by the petitioner before such authorities. The petitioner ought to have approached the jurisdictional magistrate as per the provisions of the Bharatiya Nagorik Suraksha Sanhita 2023 B and SS within bracket earlier, the Code of Criminal Procedure 1973. Yes, miss.
Obliged, Lordship.
You go to the magistrate.
18. Item 18.
This case, Women and Child Development is the party lordship, their sub copy to us.
May I please, your lordship, matter relates to non-payment of area rent, lordship. The petitioner house was taken.
So all needs to be served upon the, who is the standing counsel? No, he said that that day he came. I'm not the standing counsel. He came that day because I recorded his absence as the standing counsel, Women and Child Development Department. Then at 4:15 or 4:30, he came, said, I'm not the standing counsel. Why you are recording my absence?
Then I.
Heard Miss
K. Laryanthang.
Learned counsel for the petitioner. If there is standing counsel, then you hand it over. And Mr. S.S. Day, Learned Junior Government Advocate Assam, for the respondent, all the respondents. Those two.
Lordship, my prayer is that kindly stay the impugned order dated 5/8/26.
Oh, I cannot.
Lordship,
What is the
annexed,
order?
page 21. Annexure 7th.
During, immediately clear.
They are
of
going
this-
to shift the office, Lordship, without paying the arrear rent, Lordship.
How can I stop? Madam?
So kindly, this
How
implement
can I
order,
stop?
Mr. Sir.
Huh? Get an injunction order from civil court. We can only examine prayer one, madam. You came to an agreement with the office.
Yes, Lordship.
At that time, had you approached this court that I am giving this office on rent to Women and Child Development Department? You on your own gave the house to on rent to that department,
Yes, Lordship.
agreed on a rate. Did you ask for any permission?
No, Lordship.
Huh? Agreed by non-payment of rental. By the respondent authorities in the Women and Child Development Department, Government of Assam, for the premises rented out to them for the office of the respondent number 4. Agreed by question again. The petitioner has approached this court full stop by the instant writ petition. It is a case of the petitioner that the respondent authorities have not paid the rental dues since February 2025 till date, and the respondent number 3 has recently passed an order on 5/8/2026 directing shifting of the office of the respondent of post. Hence the writ petition issue notice returnable on suit as Mr. Roy for all. No formal notice, extra copies to all.
2809, 28 September. Item 19.
Here, Lordship, he had not given self copy to PHE, he has given copy to health.
Health. You are not important, I think.
PHE.
You are PHE.
No.
Oh. What is your story? Dulumani Das. Since 1987,
1987.
you are 40 years old now.
Now, Lordship, my petitioner's father given the land.
87 at that time, you were how much of age?
Lordship, 1 or 2 years, Lordship.
1 or 2 years.
Lordship, the respondent authority assured the father of the petitioner.
So you were running pillar from post. When did your father die?
Lordship, death certificate is.
Where?
That part is not mentioned, Lordship.
Have you mentioned when did
No,
your
Lord.
father die?
No, Lordship.
Huh?
That one not mentioned, Lordship.
Not mentioned.
Not mentioned.
So is there any record that your father lodged the protest?
Lordship,
Where is that?
Lordship, Annexure 1, page 16, Lordship.
Annexure 1, page 16.
16, Lordship.
This is Jamamonti.
This is Jamapunti,
No,
Lordship.
no. Is there any record that your father had lodged a complaint during his lifetime? When did he die?
Lordship, that part is not mentioned, Lordship. Lordship, this is the second round.
Second round.
Second
Where
round.
is the first round?
First round, Lordship, page 29, Lordship. The earlier round was, writ petition was filed seeking direction to appoint the petitioner for donating land. But
That
this
story now.
Page 19.
Page
19.
page 29.
19, 21.
Just a minute, just a minute. Let us see the story.
Lordship,
Oh, paragraph 4. Father of the petition on good faith, believing the words, allow the respondent to set up their office.
Lordship,
So this is not hostile takeover. This is not hostile takeover.
not hostile, Lordship. But without following the
That
due process.
assurance, no, 1 minute. Your story is coming out. Paragraph 4, allow
Lordship.
the respondent to set up their office.
Lordship,
And on the expectation that
that in the course of time,
might be job opportunity might be provided.
Lordship, similar situated, as the similar situated persons were given the opportunity, Lordship. So the father of the petitioner
So
was,
when he died,
Lordship,
your father died.
Lordship.
When
That part is not mentioned, Lordship.
that is the most important part.
Lordship,
That is the most important part.
Lordship, kindly peruse the.
No,
page
that is
number
the
30.
most important part.
Lordship.
When did your father die?
Lordship, I'll produce on the next date, Lordship. Today I don't have,
File it,
Lordship.
because it is not a case of hostile takeover.
Lordship,
On the expectation that job would be provided,
provided.
right? There are two kinds of compassionate appointment recognized. One is died in harness,
Hmm.
and one of the most prevalent, which is most prevalent, is in the state of Nagaland, where the land is provided against job opportunity, right? The Supreme Court had dealt with this issue that lands are voluntarily donated, allowing the state government to set up offices with the expectation that job would be provided to them, right? Then 3-4 decades pass by. The person who donated the land, he did not lodge any complaint. Then their sons and daughters, after 3-4 decades, start to make complaint. Oh, no due procedure. Then this kind of writ petition is to be dismissed. That is why I am asking, when your father died, make a statement,
Lordship,
additional affidavit,
additional.
with a date certificate.
Lordship.
Because you were 1 year old. Now, when you start running pillar from post, as you have said,
Lordship. After completion of my education, Lordship.
education, but your father was alive or not?
Lordship, I will file an additional.
Heard, Mr.
DK Sharma.
D.K. Sharma, learned counsel for the petitioner. Post up. It is submitted that the copies of the petition are to be furnished to the Learned Standing Council, Public Health Engineering Department. And he would furnish the necessary copies to the Learned Standing Council, Public Health Engineering Department within 2 working days from today. Post of Mr. Sharma has further submitted that he'll file an affidavit, petitioner will file an affidavit to bring on record the date of his father along with the concerned death certificate by way of an additional affidavit within a week's time. So place the case on so and so. The name of learned standing counsel, Public Health Engineering Department, is to be reflected in the respondent side in the call list.
2808, 28th August.
28.
Item 20.
May I please your lordship? Lordship, kindly see page number 17, my lordship.
70.
17.
Okay.
My lordship, the petitioner number 1 and 2, 1, 2, and 3 are the absolute owner of a scheduled land, my lordship. Due to the financial problem and professional constraints, they want to execute a power of attorney in favor of the petition number 4, my lordship. But accordingly, they have applied on 23rd 6, 2026. Accordingly, a appointment has been given by the sub-registrar Vishwanath Chariali. Thereafter, they have visited the sub-registrar office, but the sub-registrar refused to register the same on the ground that some part of the land is subject of a pending civil suit pending before the civil judge Gauhati.
Okay. Heard Mr.
L.M. Rahman.
L.M. Rahman, learned counsel for the petitioners. You should have made the, okay, addition. Revenue. Yes. Additional, Mr. A. Bhattasaiji, learned standing counsel, revenue and disaster management, government of Assam, for the respond number 1, 2, and 4. 4? 1 and 2. Mr. B.J. Talukdar, learned senior counsel, stated by Mr. P.K. Medi, learned junior government advocate Assam, for the respond number 3 and 4. First off. The case of the petition is that a general
Power of attorney.
irrevocable general of power of attorney was submitted before the respond number 4 for registration. And as per the pre-registration summary, date of registration was scheduled on 24/6/2026. So when the petitioner appeared before the respond number 4 on 24/6/2026,
24/6.
the respond number 4 had refused to register the power of attorney on the premise that there is a civil suit pending in respect of some part of
Subject land.
subject land, some part of the land for which the power of attorney is to be registered. First of, it is a contention of the petitioners that the act of registration by the respondent of is only a ministerial act. Issue notice returnable on so and so. As so and so appear accepted. No formal notice, extra copies. The respondents are to file their responses before the returnable date.
Obliged.
28 September, 2809. Item 21.
Very good, Lordship.
When matter is relating to by the transfer of land between the two communities, man. And the private respondent, we entered into agreement 2022, man. Out of 45, 41 lakhs already paid, possession given to me. Subsequently, my lord, the purchase, that is seller, denied to execute the matter. So I filed a case, madam, especially performance. And kindly see the order dated 41, madam. Page 41. They return the plaint on the ground that there is a notification by the government.
On that we will not look into judicial order in writ petition.
So that, but only because of the, just kindly see on the order. What? Page 43, operative part. But 41 starts, my lord. And 43.
There is order 7, rule 10. That is
yeah,
to be by
Right,
CRP
right.
227.
That is there, madam. But your worship kindly see that return the plaint because of that page 41, my lord, second last, page 41.
Page 41, yes.
Page 41. During the pendency, my WS file, everything is done, then thereafter, my lord, this.
No, what you are challenging here.
I am challenging the notification.
Okay, that's all.
Notification.
That is all.
That's-
Because we cannot look into judicial orders.
That's true. That, your worship.
We cannot interfere with judicial
Yes.
order. For that, you have to
Though I,
approach under Article 227.
that we have also, here also, my lord, 227 is.
So you are 99/2025.
Yes. 9/20.
That is, Lordship, my limited knowledge, that should be challenged before the division bench, Your Lordship. It's a
No, this
gadgeted
is-
notification, Your Lordship.
Where from you are saying?
DB Tahibun bit.
Hmm?
Lordship, since it is a gadget notification.
Yes,
Your
it
Lordship.
it is, but source is not there, not statute. It is not statute. Is it a statute?
It is not a statute, but Your Lordship, this is being followed. This is being
Not followed. We are entertaining now the writ petition. Yes, Mr. Gogoi, Additional Advocate General. Yes, please come. This notification has been challenged. Now, Ms. Borlo has said it is, since it is gazetted, it is to be challenged before division bench.
Only rules are
Heard Mr. H.R. Chaudhary, Senior Counsel listed by Mr. A.H.M.R. Chaudhary, Learned Counsel for the petitioner. Ms. Ann Bordeloi, Standing Counsel, Revenue and Disaster Management Department for the respondent number 1. Mr. B.J. Taludar, Learned Senior Counsel listed by Mr. P.K. Medi, Learned Junior Government Advocate Assam for the respondent number 2 and 3. Post of. In this writ petition under Article 226 of the Constitution, a challenge is made to a notification. Page.
Page 44. Page 44.
To a gazette notification dated 9/9/2025 of the Revenue and Disaster Management Department, Government of Assam. Issue notice returnable on so and so. As so and so. Why respond number 4? Respond number 4 has no connection with the challenge.
The instance of my lord, that case was filed. That's why.
No, that is a specific performance.
The mode of my lord challenge is there, my lord. We
You have
not
to stand on your own leg
Yes.
in respect of challenge to the notification. Why you are
Ultimately, question will come, my lord, because why this case? Because of that
This-
person.
that specific relief
Yes,
case? I will not look
that's
for a moment also,
right.
right?
I am also not
And why you are bringing that respondent
right.
to litigation for incurring cost of litigation expenses?
That is maybe start because if it is confined to the gazette notification, of course. Not
It is up to you, but that is an unnecessary party. She will be an important party in your petition under Article 227,
227.
not in writ petition.
That's
If the challenge is this, okay, Issues on steps. Borderley 1. Medhi 2 and 3. Extra copies. Step 7, respond number 4 by speed post.
Stuck up on.
2 working. You have made to start
28
up also,
July.
you have to make an I
Yeah.
nowadays.
Your worship, I am not pressing so far, not questions.
Mr. Choudhury, Senior Counsel, has submitted that no notice need to be issued at this stage to respond number 4. In view of such submission, no notice is required to be, no notice is ordered. Issuance of notice is not ordered in respect of respond number 4.
28 September, 2809.
28 September.
May I please, your lordship. Lordship, I am a small businessman, a fish trader. Matter is regarding defreezing of bank account, your lordship. I was having a bank account with the HDFC Bank, Badarpur branch, through which I receive payment through QR code and UPI, etc. Your lordship. Suddenly, my account has been frozen.
Since when?
Since May, your lordship, and without any information, without any intimation, your lordship.
Heard. Mr. M.A. Borhuya.
Your lordship. Your lordship, I have voluntarily lodged a police complaint and also written
Counsel
submission
for
to
the
the bank.
petitioner.
Annexure
The
2 and 3,
petitioner
your lordship.
has stated that.
I have also annexed, your lordship, a similar order of the Honorable Gauhati High Court. That is on
He has been maintaining a bank account.
page 13 to 19, annexure 4.
A current bank account number. So and so. With the respond number 4 bank. And he carries out his business activities relating to his proprietorship firm, Messrs. Raju Fish Market through the said bank account, current bank account. Full stop. The petitioners approached this court by their present petition. As, according to him, the said current bank account of the petition has been kept locked by the respondent number 4 without any prior notice and without disclosing the reason for keeping the current bank account locked. Full stop. It is submitted that the petitioner has no connection with any alleged criminal case. Full stop. Para. Issue notice returnable on so and so. Mr. Vijay Talda, Senior Counsel, estate by Mr. P.K. Mehdi, landed Junior Government for the respond number 2 and 3. So as Mr. Mehdi has appeared accepted notice for 2 and 3, no formal notice. A petitioner shall take steps for service of notice upon the respondent number 4 by speed post to need to work in this from today. Post of this court is of the view that no notice is required to be issued to the respondent number 1 at this stage. Para. Last word,
28 September, 2809.
or assignment? Suspicious.
Item 23.
May be jealous. Matter relates to non-release of compensation, land compensation and Jirat Milo. Those who can receive
Land compensation and GR.
Milo. Those who can receive page 13 Milo.
Page 13.
So 15 Milo, sir.
15.
15 Milo. First of all, after geotaking Milo, the respondent authority
15.
After geotagging, my lord. as
This
per
notification is under what? Section?
Lordship, 20, in the year 2023.
On which date? 20?
21.
Date is what?
21st July to 23. First notification, my lord. Here, Lordship, reflect the two plot of land was acquired by the national authorities, my lord.
Two plots of land.
My lord, serial number 19 and 24, my lord. Yes, my lord. Thereafter, my lord, they published in website, my lord, page 23, my lord. My serial number is
23.
page 23, my lord. Page serial number 24, my lord.
Page 23.
Page 23, my lord, and serial number.
Just a minute. 20. Where is 23? So what's page 23?
Oh, okay. 44. It's 46 years. Double. That it was some mistake, my lord.
Get it rectified before the registry.
My- Sorry.
Today it is all right, but suppose it comes before another bench.
Good.
Then the other bench may come hard.
Yes.
Mr. J.A.U.N.M. Loskar, Learned Counsel for the petitioner, has submitted that there are certain defects in the pagination of the writ petition, and he wants to clarify or rectify or file afresh.
Can you allow me to rectify?
Rectify. And the pagination of the repetition, pagination of the annexes, annex to the repetition, and he be granted 1 week time to rectify the defects. Mr. N. Goswami,
5, 6, and 7.
Junior Government, okay, and Bodoloi, Revenue 4, and Goswami, Learned Junior Government, Bukit Assam, for the response number 4, 5, and 6. Sorry, 5, 6, and 7 are present. In view of the above submission made by Mr. Loskar, raise the case after week.
25.
May it please your lordship. Lordship, this is also the same as the one annexed, your lordship, the same revenue circle from Bilasipara under 1974 Act. Simple.
Where is your Kotian? No Kotian.
Lordship, they have provided Chitha certificate, your lordship, in annexure number 2, your lordship.
Which one?
Page number 16, your lordship.
This is Sorkari. Dokoldar. Dokolkar. Dokolkar. Where is your Kotian as an occupancy tenant? Same hetu agor kiman asil. What is your earlier petition number? Item?
Lordship,
13.
13.
Same.
Notice.
Notice only. 1 bigha, 4 katha, item 13 silo. 15 letters. Same. Parties are same, respondents,
Yes, your Lordship.
numbers are same.
Lordship. Much obliged, your Lordship.
Item 26.
May I please, Lordship? My lord,
For the,
compensation, Lordship. My lord, we invoke.
just a minute, Mr. Hussain. You say that 3 bighas, 8 lessers from different
Ducks.
3 different ducts have been acquired, but they sanctioned only for 1 bigha, 6 lesser.
Lordship, that is not to as per solatium, Lordship. Not no market below, nothing solatium is considered, Lordship.
No.
Lump sum amount.
Slight different facts will be different. You say 3 bighas, 8 lessers have been acquired from 3 different duct numbers. 1 bigha, 6 lesser. For that, you have been paid some amount.
Yes, Lordship.
Right?
Lordship.
That is in 2 different duct numbers.
Lordship.
That is 6,67,800.
Lordship.
Right?
Lordship.
Now, if on that amount, solatium market value is not paid,
Lordship.
for that, this is not the forum.
Section 11.
Right? But if an area has been acquired without paying compensation, that can be examined. Have you understood?
Lordship.
You are clubbing both.
Yes.
If market value is not paid, you have to approach the district judge through
Deputy Commissioner.
Deputy Commissioner or what?
Alia.
Now referral authority.
Can't-
Market value not paid, solatium not paid.
paid.
Issue notice.
We
the
have done
district-
that, Lordship. Page 56. We have invoked.
This is
656, Lordship.
1 minute. Let us see your documents first. What are those lands?
Lordship.
Where are your, have you made the
from-
description?
from
Have you
page-
made the description of your land?
Yes, Lordship. I have made description and documents also annexed from page 17, Lordship.
The, how many petitions?
One petitioner. One petitioner, Lordship.
Heard Mr. M.I. Hussain, Learned Counsel for the petitioner.
Lordship, one latest development is also there. In the meantime, after filing this state petition, I am informed that they are evicted by demolishing their house. Already.
The, who is PWD?
Lordship.
Okay, S. Sharma, Standing Counsel, PWD. For the respond number 1, 3, 6, 7. And Bodoloi. Revenue. 2.
I got 4, 5 and 8.
And Goswami. 4, 5 and 8. Post. It is a case of the petitioner that his father owned 3 plots of land. Para 3. 4 bighas, 6 lessers, comma covered by Dag number 215 under Patta number 54. Roman 2. 2 plots of land?
2 plots.
You say 3 in a synopsis.
In synopsis, it is wrongly typed. Lordship.
Wrongly typed, sorry.
Sorry. Lordship.
That is the only word. But you
In the synopsis.
misled. 2. 2 bighas, 1 katha, 3 lessers. Covered by Dag number 72. Under Patta number 216. Situate at Sodhurir Sor, Part 1. Athani Revenue Circle, District Dhuri, Assam. The quote-unquote subject plots for short. Full stop. The subject plots were being cultivated by the family of the petitioners, and in the subject plots they have their dwelling houses also. First, there are standing betel trees and bamboo bushes. First of, after the death of the father of the petitioner on 21/8/2022. The subject plots are inherited by the petitioner and his brothers. First of, in the year 2019, the respondents have entire area.
They say partly, but a bridge is being constructed over that plot of land. So our
Respondents have constructed a RCC bridge on the subject land, and for that purpose, it was represented before the civil suit also. What? Huh? Some civil suit also.
no civil suit is not there, Lordship. They
Why have annexed something?
they served a
Section
notice.
80.
They served a notice, Lordship, upon the executive engineer. They served a notice. And to that they have also replied.
Under the provisions of Assam Land within bracket Requisition and Acquisition Act 1964. First of, according to the petitioner, they are not paid compensation for the entire subject plot. So the respondent authorities had only paid a sum of rupees 6,67,800 for an area measuring 1 bigha 6 lesser without making any payment towards Solicium market value and zero value. Aggrieved thereby the petitioner. With such projection, the petitioner has approached this court. Where is that award?
Award, Lordship may kindly see page 46 and 48.
Only paid so much 6 lakhs. Under award number 2 and award number 3 in LA case number 2/2023-24. You are paid or not paid?
Not paid.
Okay, not paid, huh? Good. Your synopsis is not complete. You should notice. Difficult. Returnable answer. As Mr. So-and-so, no problem into this extra copies.
2809. Of my left. Supplementary list, item 49.
May I please, Your Lordship? Lordship, this petition is similarly situated with earlier writ petition number 2312, in which Your Lordship was pleased to dispose of the matter with an providing an
We don't know what is to other petition. What is the matter about Mr. Roy?
Lordship.
Yes. Madam Bordello, you look into this order and if any correction is required, we'll do it. If it is possible to be disposed of in the same line, Mr. Roy, look into make the correction. If it is possible, make the correction. After some time, let them look into it.
Item 50. Item 50.
What is the issue here?
Your Lord, the petitioner, my Lord, she was elected as member, subsequently as president.
A
And
member of Gamashar.
Lordship.
Okay.
Subsequently, she was elected as president, my Lord. Now, after about 1 year, my Lord, 6 members filed a complaint regarding alleging age dispute of my child marriage.
Okay. Okay.
then they file a representation before the deputy commissioner. Then chief executive officer of this Jila Parishad, my lord, he issued the show cause notice. So we have approved this.
So, okay, Mr. Dotto was supposed to take.
My lord, the who had complained, my lord, they are not made parties here.
This is somewhat akin to those.
My lord.
That one also. And in that judgment, what is it? Ayasa Khatu.
Yes, ma'am.
It said it has to be by way of a reference.
My lord.
To the deputy commissioner. At one part,
Right.
it said it had to be the district commissioner does not have the original jurisdiction.
He has the jurisdiction.
Jurisdiction to decide.
Before nomination.
Referral jurisdiction.
Oh, there are many things. It said, I'm trying to reconcile. It said in one part that deputy commissioner can only look into a complaint when it is referred to him. That is one part in the judgment.
My lord.
Is it not?
My lord,
If I have
the
understood correctly.
main point of that judgment.
Main point is something else.
Something else. 120.
Regarding nomination.
Yes.
So nomination by way of an election petition, if it is.
If
that is already allowed, then only recourse is by way of a nomination, election petition.
commission.
But before that, it had gone into Rule 62 and said that for a Gram Panchayat member, it has to be originated from secretary.
Yes. This is the law. Yes. My lord.
The court said.
Yes. In fact, the law also says.
If I'm trying to reconcile.
My lord.
If it has to go from the secretary upwards.
Yes. Yes.
Right?
My lord.
Then only by way of reference, district commissioner can act. The provision said.
Provision, yes.
But at the end, it reached a conclusion, nothing doing.
Nothing. In the Aisha's case.
No, my lord. Why that was, my lord? The rule is saying, my lord, from the secretary to the district level, my lord. But the Aisha Khatun is saying, my lord, district commissioner has jurisdiction and the rule applies only when, my lord, the violation of disqualification clause, my lord, subsequently to the election, my lord. Aisha Khatun is saying only that part, my lord. Para 75.
No, if this is by way of the election petition,
my lord,
where is the requirement to discuss all this? If it is only election petition.
My lord, in case of pre-defect, my lord, election petition. Lordship has already fixed similar matter, my lord. I will satisfy on that points.
So it boils down to that. In case of two child, that's sanitary thing. And what is the third one?
Education. Educational qualification, minor marriage.
No.
Well,
don't mix up.
Yes,
that had decided only minor marriage.
My lord, in the second case, all those laws has been discussed.
Then it is difficult.
Field of case.
Then it is difficult.
My lord, in fact, in the rule also, my lord, in those cases, in those situations, where, my lord, the subsequent violation is, my lord, the subsequent violation can be held, my lord.
All these Javed and all other 5 judgments are discussed.
Javed?
Supreme Court. No, not only Javed.
My
there are other 5 decisions. Right. One is sure.
Yes.
This court has also held in Panchayat
Yes, yes.
delimitation.
My,
That from the date
my lord.
of election notification
Right.
till the declaration of result,
Right.
a petition except in exceptional circumstances under Article 226
My lord.
is not to be entertained.
My lord.
And nothing else. Any complaint, whatever, only by election petition. But that is, all those decisions are regarding parliamentary and legislative assembly election.
Right.
But Supreme Court has carved out an exception in case of Panchayat elections. That what is applicable in parliamentary election or legislative assembly election may not be applicable for Gaon Panchayat
Yes.
member
My lord.
if having a constituency of 6,000
Right.
electors.
My lord, I have already prepared one note, my lord, for all the judgments, my lord. I'll submit on
This
the.
requires, Mr. an examination.
Yes.
Lordship.
Notice may be
Notice
issued.
On 14/8/2026, Lordship.
Nambood Hidwar Ali petition. As Doctor.
1 and 3.
1 and 3. SS Roy. 2. And B Castro. 4. Mr. Doctor has submitted that he is yet to receive the instruction regarding the factual events leading to issuance of the Sloper's notice dated 27/7/2020. Let notice be issued. Notice is made returnable on so and so.
174.
As so and so is appeared accepted. No formal notice, extra copies. The interim order passed earlier shall continue till the next date.
29/09, 29 September.
My lord.
Your Lordship state the.
Interim order passed earlier.
Item 51.
I'll oblige me.
Please, Your Lordship. Your Lordship, a clarification was sought as to the quorum of the real
So
estate appellate.
firstly, the chairman or presiding officer is not there
Indeed, Your
as on date.
Indeed, Your Lordship.
And appellate authority consists of how many? 3.
Three, indeed, Your Lordship.
Three.
Composition.
So one is not there. How many are there?
Now, none of them are there, Your Lordship. All posts are vacant.
All posts are
But
vacant.
your clarification was
posts are-
sought. The quorum is also the quorum.
All posts are vacant.
Indeed, Your Lordship.
All posts are vacant, it is okay.
Indeed. All posts are vacant.
Okay, coming to the merit of the case. Yes. What is the order?
Your Lordship, the order is at page number 142. There is a mandatory obligation wherein a quarterly progress report under section 11 of the RERA Regulation and Development Act 2016 is to be provided. Due to certain difficulties, Your Lordship, we were not being able to file it. And the same had been communicated by mail before the date of hearing. That the mail is on page.
No,
Page
these are the requirements.
Indeed, Your Lordship.
This QPR
Indeed, Your Lordship.
and after registration of the project in the RERA.
Indeed, Your Lordship.
And those are for the period 2023 onwards.
Indeed, Your Lordship.
Is it not?
Indeed, Your Lordship. We are conceding to the.
It is not that single
Indeed, Your
default,
Indeed, Your Lordship.
repeated default.
Indeed, Your Lordship. Your Lordship, the problem was, Your Lordship, there was a congestion in our thing to apply only, Your Lordship. Our setup, Your Lordship, was as such. Your Lordship, and plus we are conceding to the fact that yes, there was a delay.
Go
We
by
have
the
to-
provisions. There is no
Indeed, Your
escape.
Indeed, Your Lordship.
And for period of 3 years.
Indeed, Your Lordship. Indeed, Your Lordship. We are conceding to the
Had
fact
it been a single default,
Indeed, Your Lordship.
Your Lordship, Your Lordship, as of today, we have complied with it. We are not denying the fact, Your Lordship, that we have to concede because it is as per the records, we have actually filed it subsequently, Your Lordship. But our filing, Your Lordship, was because of certain technical difficulties also, Your Lordship. We couldn't get ourselves registered at one point of time, Your Lordship.
But the question is,
Indeed, Your Lordship.
had it been a single default, yes, I could have. But
Indeed,
it
Your
is a case of repeated defaults for a
Indeed.
period of 3 years.
Indeed, Your Lordship. Your Lordship, we are conceding to that fact, Your Lordship.
Right. So,
We have to concede to that fact.
and it is a case of, it is not a case of no notice. You did not even bother to appear before the authority. That is a statutory authority.
Indeed, Your Lordship.
You just sent a mail. And it is not that single default
Indeed, Your Lordship.
to excuse, to exercise a power. It is a
Indeed.
repeated default, third, fourth, fifth paragraph.
It has been a subsequent default because our credentials were not uploaded at that point of time. Because our credentials were not uploaded, by default, all the periods we have been defaulting, Your Lordship. Once the credentials were made, Your Lordship, that same thing we needed an opportunity to actually place before the court, but they had not sought correct information also or correct course of remedy.
So, cause notice 27 was issued to a promoter. Where is your email?
Your Lordship, at page 21, Your Lordship. Your Lordship, at the outset, Your Lordship, the promoter here, Your Lordship, is not a very educated man either, Your Lordship. So he has made a little bit of errors here and there, and he has not sought for correct guidance also in this regard.
If you want to be a builder and promoter of a RERA project,
Indeed, Your Lordship.
those are not excuses.
Indeed, Your Lordship.
That lack of educational qualification.
Indeed.
How big is your project?
It is
Consisting of how many apartments?
5,200 is the total area. So area is 55,000.
Area is?
50 something, 5,200.
Project cost was 5,009.9
9 lakhs. So it's around
5,000? How many crores?
5,008.96.
So it's like around 50 crores, Your Lordship.
50 crores.
50, 60. He had the capital, Your Lordship, but Your Lordship, there is
No, stay. You deposit. Earning builders have to.
Your Lordship, at least, Your Lordship, a little bit of commutation for Your Lordship. Our prayer would be limited to a little bit of commutation of the amount, Your Lordship. A little bit of commutation of the amount, Your Lordship. Our prayer will be limited to that because we have to concede, Your
For
Lordship.
repeated 3 years,
Your Lordship, because the
this
credentials.
is reasonable.
Credentials, that is the maximum penalty anyway they can impose for everything, Your Lordship. Everywhere the maximum penalty has been imposed.
You deposit.
Your
This is
Lordship, the
not a case
maximum
for
penalty has
interference. It is not, had it been a single default, I could have. The court had, the authority had recorded.
Your Lordship, the problem was that the credentials were not uploaded at that
For
point.
lapses,
Your Lordship, we are
you
conceding to the
are
fact.
not a
Indeed, Your
person who is to be shown some leniency.
Your Lordship, being the officer. of the court-
Yesterday, I showed leniency going out of the way
Indeed.
to a person, different thing. But for a petitioner of this kind,
Indeed.
not to be shown leniency. We can only issue notice, no stay. I am not interested to pass any order of stay for
Your
this.
Lordship, being of the court's opinion, Lordship.
Yes, we exercise our discretion.
Indeed, Your
Yesterday, I exercised my discretion under 226,
Indeed, Your Lordship.
going out of the way
Indeed, Your Lordship.
for a person who is indigent.
Indeed, Your Lordship.
But here is a case undertaking a project of Mr. Roy, 50 crores. 50 crores. and repeat defaults for 3 years at least on the record in black and white.
Indeed, Your Lordship, because of
So only we should notice to
Your Lordship,
examine, to
Your
examine.
Lordship, due to financial constraints, one block was not made only because no booking was got. It's a very cyclic business, Your Lordship, and it
Yeah,
depends.
you
Lordship, why-
take the risk, you go by the risk.
Your Lordship, that the very fact that we are conceding to the fact
This
that
is the
there is a
amount
default.
that authority has the discretion,
Indeed, Your Lordship.
right?
Indeed, Your Lordship.
So this is not to be interfered with, and seeing that 3 years.
Indeed.
Otherwise, say in a what is the law with regard to imposition of penalty by a disciplinary authority? Right. It has the full discretion to pass an order as minor penalty or major penalty. It may pass a dismissal order. It may pass an order reducing downgrading him or stopping increment. What the law says that unless it is an exceptional case,
Indeed.
you hand your hands off to disturb the discretion exercised by the disciplinary authority.
Indeed.
Supreme Court as well as High
Indeed,
Court. You hand
Yes, Viswas case. Indeed, Your Lordship.
So it is not a case. The present case is not a one to have an extraordinary situation.
Your Lordship, the only submission was, Your Lordship, because the credentials were not created, it looks like it is for a period. It is a violation for
3
period of
years.
3 years. Indeed, Your Lordship.
3 years.
There is a point. Your Lordship.
Not possible to exercise our
Indeed, Your Lordship. Your Lordship, commutation was we are only limited to the period of commutation as of now, Your Lordship.
You have complied better late than never regarding
We have complied.
PR.
Indeed.
But we will not disturb with this. We will issue notice only. We will not pass any order of stay. Erring builders.
Indeed, Your Lordship.
We issue notice.
Much obliged, Your Lordship.
Heard Mr. M. Borua, learned counsel for the petitioner. It is not that we will not examine,
Indeed, Your Lordship.
but
I
no stay.
being the officer of the court, Your Lordship, I understand.
And
the-
Mr. S. Roy,
Respondent
learned
number 3.
the new government advocate for the respondent number 3. The petitioner has approached this court invoking extraordinary jurisdiction of this, extraordinary jurisdiction under Article 226 of the Constitution to assail an order dated 19/5/2026 passed by the respondent number 1, whereby a penalty of rupees 3 lakh has been imposed upon the petitioner as the promoter of a RERA registered project,
Indeed. The project registration numbers.
which is to be paid within a period of 3 weeks from the date of the order. Post up. The petitioner has also been directed to upload all the pending QPRs within 3 weeks from 19/5/2026. Post up. Para. In the order dated 19/5/2026, comma, from the order, it is noticed that submission of the respondent number 1 has observed that submission of quarterly progress reports, UPRs, in respect of a registered real estate project is mandatory under the provisions of the Real Estate within bracket Regulation and Development bracket close Act 2016 within bracket RERA Act for short, and the rules and regulations framed thereunder. Full stop. In the order dated 19 in the said order, comma, the respondent of 1 has recorded on the basis of has observed on the observed that from the records, comma, the petitioner was found to have defaulted in uploading the QPRs from the second quarter of 2023 till March 2026. Full stop. Para Mr. Borua, learned counsel appearing for the petitioner, has submitted that after the order dated 19/5/2026, all the pending QPRs have been uploaded. Full stop. The matter regarding quantum of penalty imposed upon the petitioner would require an examination issue notice returnable on so and so as Mr. Roy. 3, no formal notice, extract of his states upon respond number 1 and 2 by speed post within 2 working days from today. We'll examine.
Much obliged.
3009.
Much obliged.
Oh, before that, just a minute. Mr. Borua has submitted that as presently, comma, there is no member in the, what is that?
Real estate appellate tribunal.
Real
Estate.
which section? Otherwise, what is the
Real estate appellate tribunal. This is
real estate appellate tribunal, comma, the petitioner could not file an appeal before under section 44 of the RERA Act before the appellate tribunal. To file an appeal, you require pre-deposit also.
Indeed, Your Lordship.
All entire amount had to be deposited.
Your Lordship, 30% has to be deposited for an
Okay.
appeal. But we were saved by the grace, Your Lordship, if that is the.
But you have to comply.
Indeed, Your Lordship, we will come. Much obliged.
52.
Yes, Mr. Soikia. What is your prayer? Long prayer. What is such prayer? Respond number 1, 2, 3. Who is respond number 1, 2, 3? Not to harass the video mentally impacted in peaceful position of land under the position of the petitioner who had foreign lands not belong to the read in a major manner. What is the case? What is the case?
Case matter the petitioners, they are occupiers of government land. And Mati, ward number 4, Moriari. They are possessing the land 1954, the wards till date. They are paying land revenue, action of public land, mineral personal land, municipal taxes, other taxes. Although the land not belong to the railway authorities are disturbing them. This last few weeks.
Have they served any notice?
Nothing, man. But they are visiting the areas of the petitioners, man. Asking for land documents, everything.
Where is your statement?
Page 15. Oh, sorry, paragraph 15. Page 12. But yesterday also some of the railway authorities.
Yes, with who is railway? You have to represent railway also. I don't think nowadays there is railway council.
Yes. There is no surprise.
Is there any move going on?
My lord, that I have to take the instruction, but so far this writ petition is concerned, my lord. Nothing is cause of action, nothing is. Not a list
But
of that.
verbal visiting the place and verbally
that I have-
threatening is also a cause of action. It
that
is
I
not
have-
that.
That I have to.
It is
take-
not that.
That I have to.
They are in their land, according to them, they are having possession of the land since long.
For
But
that-
if you go there and threat,
For
that,
that, I have to take the, for that I have to take the instruction.
take your instruction.
My lord.
But any process of eviction must have to be preceded by a prior notice. That's all. I will not state, but anything, any process of eviction must have to be with a prior notice. Railway or state, whoever. We have seen also bulldozer law nowadays. It can't be ignored. I have seen many list লগাই থব নম্বৰ কেইটা লগাই থব Mr. Authorised ji has to answer. We have seen bulldozers, demolition, photographs are there, bulldozers, JCBs, they are of the same kind. JCB or bulldozer are of the same kind, but these also cannot be presumed because of bulldozer actions. Is it whether railway is in contemplation, why they are visiting this place? If it is a railway land and the petitioners are in unauthorized occupation, then the Public Premises Act has to be followed. It is just for the measurement you visit, okay, right? You take measurement and thereafter you find it that this is actually a railway land, not municipal land. Okay. But they are saying threat.
That I have to take.
So you take instructions. Monday?
Till then, my lord, possible. That may be observed. All the petitioners, my lord, has.
Heard Mr. P.J. Soikia, learned counsel for the petitions. Mr. V.K. Chopra, learned central government counsel for the response number 1 to 3. 4. Mr. A. Bhattacharya, learned standing counsel revenue department for the response number 5.
6 and 7.
And Mr. S.S. Roy, learned junior government advocate Assam for the response number 6 and 7. The petitioners, 16 in number, have joined together to file this writ petition, stating that they are in occupation of a parcel of land since long, parcel of land since long by paying municipal taxes, property taxes to the
Land revenue takes revenue also. Land revenue also.
Then why you are not making this municipal board party? What kind of revenue?
My lord pays.
What kind of revenue?
My lord say.
Land revenue or Bedokholi Jorimona?
No, it does not say so, my lord. Revenue. Pays 20.
Huh?
Page 21.
Where is that?
Page 21 onwards.
Bedo. So Bedo.
Somewhere it is.
If all are similarly situated, all are Bedo. By paying revenue, land revenue, to the state respondent authorities. So, it is a case of the petitioner that the railway authorities have been visiting the parcel of land repeatedly in the recent times and have threatened the petitioner that they would be evicted from the parcel of land on the ground that the petitioners are in the parcel of land which are in the occupation of the petitioner railway land. Post of para Mr. Roy Learned Counsel for the Learned Junior Government Advocate appearing for the respondent number 6 and 7. Mr. Bhattacharya and Mr. Roy have submitted that the petitioners might be paying encroachment penalty. Encroachment penalty. Within bracket, Bedokholi Jorimana. Post of para Mr. Chopra Learned CGC appearing for the respondent number 1 to 4 has submitted that as per the pleadings in the petition, comma, the railway officials have visited the parcel of land only for the purpose of taking measurement. So, he will obtain instruction as regards any contemplated the region for paying such visit to the parcel of land under the occupation of the petitioners, comma, as alleged in the writ. Post of. As affirmed by Mr. Chopra, laid the case on Monday. Para. It is observed that there shall not be. There shall not be the status quo as obtained today shall be maintained till the next.
My name 24th August.
With regard to the parcel of land, till the next date of by the parties till the next date of the name of Mr. B.K. Chopra, CGC, is to be declared in the respondent side.
2408.
You need a copy?
One.
Mr. Soikia, and also for the petition, shall furnish a copy of the petition along with an annexer to Mr. Chopra during the course of the day.
Time being matter, item 49.
Huh? At 2 p.m. Can be disposed of.
Supplementary list. Item 49.
Any applications? 25, 26, they, huh?
2 year.
Two. For two different plots of land or what?
Page 24, 25.
The number date is same, but numbers are different.
Amanur Hussain, one
Huh. Both Amanur Hussain.
25 November and 16 December 2023. Submission date, Your Lordship.
Okay, both different. By the same person.
Same person, two different applications.
Okay. Out of the same four kathas,
Yes.
you are in possession of what area, Miss Madam? Four kathas, 57. This is different that number.
Page 4, Your Lordship, paragraph 2.
Paragraph 2,
Yes.
four kathas. Okay.
10 less.
Utah se, huh?
They have applied twice for the same plot of land, Your Lordship.
Twice.
Yes, for the same plot of land. Yeah. 24, 25 page number. It's a developer.
Similar place of Name two, Miss J. ER and Mr. S.S. Roy. PM code.
Pledge, Your Lordship.
Daily list for admission, item 27.
Kindly pass over the matter for the time being, Lordship.
Item 29.
Yes.
As per Lordship direction, we file in rejoinder affidavit, Your Lordship.
What is the issue here?
Lordship, the petitioners have been served an eviction notice dated 12/1/2000.
Which one? Page?
Annexer 1, Your Lordship.
Annexer 1?
61. Common eviction notice, Your Lordship.
Okay. So what is the,
After the petitioner received the notice, they went to submit their documents. The lot Mondal in the circle have received the documents, and as on date, no hearing has taken place, Your Lordship.
why this notice is bad?
It's no, sir, as per 18(2), Your Lordship, it should be, every notice should be served individually, Lordship. It's a common notice. As per the notice, we have went to the lot Mondal office. He have collected the documents and informed us verbally that we'll be called for the hearing, and no hearing has taken place, Your Lordship.
This is grazing reserve.
Yes, Your Lordship.
Sorkari Gorabad.
Yes. Being landless, we have been in possession of this land, Your Lordship. And similarly, the land have been given settlement, Your Lordship. Similar other ducks.
Tag number 14. What is the stand in a affidavit? Government
Lordship,
affidavit?
that this is a government cast land, they were occupying my lord. We have issued notice dated 12/1/2026 and directing them to be present for a hearing on 17/1 and 18/1. That Lordship, on those two dates, they appeared before the authority but failed to produce any document to substantiate their claim. Lordship, may kindly come to paragraph 4 of our evidence. last part of paragraph 4, my lord. The petitioners were given opportunity to be heard of any claim to show the valid documents, records before the circle officer or evidence officer fixing the date for hearing. The petitioners failed to produce any valid documents record during this time of hearing. No. 13 calls, 9, 13 and 21. Paragraph 13 at page 152.
They are saying that they submitted their replies, annexing all the documents, but no acknowledgement
No action.
was given. No acknowledgement was given.
I do not have a copy of
Affidavit
the,
in reply,
that I do not have. He has not brought this out.
because in a say, in many other cases,
No, no.
direction was made, a set of directions that they should acknowledge the receipt of the representation.
Lordship, I have some, subsequently I have received.
Because
some-
you have said, no, nothing has been, this is contrary to their claim.
No, Lordship, we have.
You said in your paragraph
4.
4, they fail to produce any valid document.
Yes, ma'am.
They are on the other hand saying in the affidavit in reply, whatever, rejoinder, that they submitted their documents before the respondent number 4,
Yes.
along with available land-related documents, revenue records, and other supporting materials pertaining to their possession and occupation of the subject land for more than 40 years. Then those were received by Lat Mondal. Despite repeated requests by the petitioner, no acknowledgement or receipt was issued by the Lat Mondal in respect of the documents so submitted. He orally informed that they would be called subsequently for a personal hearing, further verification.
Yes. Some personal hearing was given to them.
No, you said that they failed to submit any documents.
Yes, Lordship.
They are saying they submitted documents.
Only, my lord, what they have submitted on a subsequent instruction I have received.
Because your affidavit says.
My affidavit says
They fail to produce any valid document, records.
Lordship, may
during-
kindly come to paragraph 13 also. That with regard to statement within so and so, it will deponent Baxter state that the petitioners were given opportunity to be heard of any claim or show any valid documents, records before the circle officer so and so by fixing date for hearing. The petitioners failed to produce any valid document,
Right,
record.
valid will be valid, decision
No,
on valid.
what they have submitted only the Bedokhali Jarimana receipt, nothing more than that, man. This is my subsequent instruction. Pursuant to your lordship's direction, I have.
Which judgment says individual notices?
Salakuddin, your lordship.
Individual speaking orders.
But notices are not
Individual
said
speaking
individually as per
Ah,
Salakuddin.
that is why, because you said individual notices, that
Yes,
is why.
yes. No individual, it's common notice, your lordship.
No, individual notices, Salakuddin.
Yes,
Individual notices or individual speaking orders? Two
Notice
things
or-
are different.
yes.
Which one?
Notices, your lordship.
Notices, which paragraph?
Paragraph 11, your lordship, page number 29.
Paragraph? Yeah.
In our petition, your lordship, page number 29.
No, in Salakuddin.
18.
30.
Okay.
Individual notices.
Made a statement. No,
No, you are saying individual notices is a requirement. Where it is laid down. This is the court. In which paragraph of Salakuddin it says? You're not ready, then how can it be possible for me to look into these records? Which paragraph you make a submission that individual notices?
in our petition.
The petition, when law is laid down already
Yes, your lordship.
by different judgments of this court and Supreme Court. I remember to that extent that individual
Yes.
orders are to be passed. Now we have made a submission that individual notices are to be issued. Now, there is a vast plot of land, which is a government land. You have occupied different areas of land. Now, individual notices are to be served where it is laid down. You have to, when you are making a submission and you have said Salakuddin, where, in which paragraph?
Reasonable opportunity of been hearing.
That is one aspect. That will come later on.
Yes, your lordship.
First is individual notice. Here is a common notice.
Yes, common.
Now you are making a submission that individual notices are to be served. On the basis of which authority, which decision? That is what I am asking. Thereafter, individual hearing, individual representation, individual orders. To that extent, I know. And appreciation of whatever you have said in the representation, that has to be looked into by the authority. To that extent, I know. But where it is laid down that individual notices are to be served. If you are not ready, say so.
In judgment,
It is not possible for me to go through the judgment here.
Supreme Court also in Abdul Khalek and others,
Where
laid
is
down
it?
the procedure. That is regarding the forest land. And
No, but procedure is same.
Procedure is
But where is the individual notice?
my individual notice is not there.
In paragraph 64, your lordship, last page of the and that notices should be issued.
Notices.
No word individual is there.
Salakuddin says only proper notice. Not a-
your lordship, paragraph 64, Salakuddin specifically says occupants, possessor of the government lands have to be issued notice.
That is what?
Yeah, so it has to be served individually.
Where it is laid down.
No,
You cannot read something
Yes.
Which is not there.
yes.
It is individual reply, individual person hearing,
Personal.
and
speaking order-
individual speaking order. To that extent, I know.
Para 57, your lordship, of that judgment. This is the last part. We therefore are of the opinion that prior notice to the occupier possessor before initiation of proceedings under Rule 18 of the settlement rules is the mandate of law. That has been followed, your lordship.
Yeah. There are other judgments also a set of directions. Where are those? No, by a coordinate bench, there is a set of direction. Paragraph 50 के कौन से paragraph 50 के quote করেছিল? paragraph 50 के quote করেছিল। So, there is a set of directions in similarly situated cases. that individual hearing is to be given, an
Individual-
opportunity is to be
Provided.
afforded.
And
Individual
then
individual
if there is
representations along with the supporting documents, thereafter personal hearing and individual speaking orders.
TB hospital cases, your lordship, I provide on Friday.
Monday then. Wasting time. Tuesday की बात है? Okay, Monday. It's difficult to read all these judgments in the court. Jade Khalid for the petitioner, Vijay Talukdar, and Borderline Standing Council Revenue Department, Mr. Vijay Talukdar and Senior Counsel. State by Mr. P.K. Medila and State Council are present as sought for by the learned counsel parties. Release the case on Monday. Open video instruction. You place it on Monday. That's series of Moyudishlu. I have also given that this is the procedure to be followed. That no. Was give the number. Yes, next Monday.
Item 30. Item number 30.
I'm talking whom I told. Listen.
Should kindly peruse the last order, Lordship.
Affidavit not filed.
Lordship.
A Islam petitioner.
But affidavit,
Huh?
yes, affidavit is ready, but why not? file it?
Last occasion also in July, draft is ready. There is a submission.
And take step for filing it.
A Islam learned counsel for the petitioner, Mr. A. Aforesaid and Borderline Learned Standing Council Revenue Department. For the respondent number 1 and Mr. B.J. Talukdar, Learned Senior Counsel listed by Mr. P.K. Medila, Learned Junior of Advocate Assam for the respondent number 2 and 3. This private respondents, they have appeared.
They have not yet appeared, Lordship. Or notice have Lordship.
Mr. Talukdar has sought for listing of the case after 2 weeks in order to file the affidavit in opposition on behalf of the respondent 2 and 3. Post of the request made by Mr. Talukdar is accepted. Is the case on so and so. The interim order passed earlier shall continue till the next.
9 September 0909. Items 31 and 32.
May I please, Lordship, the interlocutory application we have prepared, Lordship, I may be allowed to withdraw this interlocutory application to file a fresh writ petition in this regard, Lordship. By tomorrow, we are going to file a fresh writ petition. Lordship.
Which one? IA?
IA, Lordship.
I have filed affidavit today, my lord. They want to do then.
This 2228.
Yes,
2228.
This is for what?
This is for during the pendency of the present writ petition, he is going to construct some pakka houses and building, Lordship. That's
For on
why-
behalf of the respondent, staying. Okay, Mr. You are the applicant here.
Applicant, Lordship.
Mr. ABT Hawk Learned Counsel for the applicant. And respondent in respondent number 8 in WPC number 663/2026 has submitted on instruction, the applicant wants to withdraw the instant interlocutory application, in order to file appropriate application. First of higher education. Who is higher education? Okay. Mr. J. Hendik, learned viewer. He is not here. Who is his representative? Mr. J. Hendik, learned junior standing counsel for revenue department for the OP number, oh, sorry, Mr. H.R.
Ahmed.
Ahmed, learned counsel for the opposite party number 1 and 2 dash read petitioners. Comma, Mr. J. Hendik, learned standing counsel revenue department for the OP number 3 and 4. And Mr. B.J. Taludar, learned senior counsel, assisted by Mr. P. K. Medhi. Revenue 5 and 6, huh? 7, 8, 9 are present. In view of the above submission made by Mr. Hawk to the counsel for the applicant, thus the instant interlocutory application is dismissed on withdrawal. Withdrawal. Dismissed on withdrawal. Yes. What about the read petition?
Yes, in the read petition, the respondent filed an affidavit, my lord.
There are 2 read petitions.
Yes, my lord. In first case, my lord. In
You are the petitioner in both the cases.
both the cases. my lord.
Okay. So they have filed affidavit in opposition.
Yes, my lord. In item number 31, my lord.
31. Yes. Are you filing any reply?
My lord. I will file, my lord.
Okay. Mr. H.R. Ahmed, heard Mr. H.R. Ahmed, learned counsel for the petitioner. Parties are same. Mr. Revenue to Agortu Likidibo. BZL to Agortu Likidibo. And you are private respondent here?
Respondent number 8.
Okay. Mr. A.B.T. Hawk, learned counsel for the respondent number 8. So Mr. Ahmed, learned counsel for the petitioner has sought for and is granted. How much time?
3 weeks. my lord.
3 weeks time to file an affidavit in reply to the affidavit in opposition filed by the respondent number
6.
8.
6. my lord.
6 in WPC number 663/2026. 6 means settlement officer.
Yes.
Settlement officer.
Yes, settlement officer filed an affidavit.
Yes.
Okay. You want to file?
I will file.
Mr. A.B.T. Hawk. Mr. Hawk, learned counsel for the respondent number 8 has also sought for and is granted 3 weeks time to file affidavit in opposition on behalf of the respondent number 8. List cases. 8 to the likhi dibo, 30, huh? 31 of likhi dibo. This is having any importance?
I am, my lord.
No, the second repetition.
Yes. This is separate.
But say separate cause of action or
Same.
Cause of
same.
same, but separate.
So affidavit filed in this case will be sufficient.
No, my lord. They may file affidavit in the second case also, my lord. Or the different petitioner. This is, my lord, college, my lord, and that is higher secondary, my lord. Petitioners is different. Issue is same, my lord.
Land
Regarding settlement of land, my lord.
Same
same. land.
plot of land or different plot of land?
Different plot of land.
Same. land.
Okay, সেইটো থাকিলটো প্ৰথমটো এইটো লিখিব HR Ahmed petitioner. School education, no, nobody is there. Mr. E. Thakuria, learned standing counsel, education department, secondary education department for the respondent number 1, 2, and 3. J. Hendik, revenue 4 and 5. B.J. Taludar, tested by so and so. 6, 7, and 8. You are not a party
Not
here.
there.
Okay. The respondents are granted 3 weeks time to file their respective counter affidavit. First of all, is the case on so and so along with 31.
Okay.
18th September, 1809. Item 33. May it please your lordship. And challenges proceeding as well as order, my lord, two counts, my lord. First is that there is no so-called, only DRC 01 is there. And second, my lord, there is a violation of section 75, subsection 4. No hearing, no opportunity of personal hearing was granted, my lord.
75 subsection 4.
4. My lord, lordship may kindly see that at page 22, DRC 01, my lord.
Yes.
And this is page 22, my lord, is DR. And my lord, page 23, lordship will find the description of schedule that in this here written, my lord, date of personal hearing not applicable, my lord, at page 23.
But this is case under 73.
73, my lord. And then at page 24, my lord, it is an attachment to, my lord, DRC 01, which they want to say this is an so-called notice, my lord.
Yes.
My lord, they want to say, my lord, since we have failed to respond to SMT 10, my lord, therefore they have issued a so-called notice in form DRC 01. That is what they have said in page 24, my lord.
Page 22
20
is DRC 01.
01.
Summary.
Summary, my lord.
Huh.
And page 24 is an attachment to DRC 01, which they want to say it is a so-called notice, my lord.
Where it is attachment?
My lord, let your lordship will find page 23, my lord. It is written here, so-called notice is attached. Just below the table, my lord.
Okay.
They say so-called notice is attached. Now this attachment is at page 24, my lord.
It is identical to summary show cause notice, almost.
My
The
lord,
figures
yes.
are
Yes, my lord.
only mentioned.
And they say, my lord, since I have
Even
not,
summary is more detailed than
my lord,
attachment.
my lord.
Huh.
Thereafter, my order has been passed at page 26, my lord. Confirming demand, my lord.
Did you make any, did you submit any reply?
No, my reply was not submitted, my lord.
Yes.
Then, my lord, page 30, my lord. Details of order is there, my lord.
In the summary show cause notice,
My lord.
what is the figure?
My lord, at page 23 figure is there, my lord.
84 lakh.
84 lakh 48,134.68.
Then in page 24 also,
Yes, my lord, same. At page
same or different?
same. Lordship find at page 25, my lord, total is given. At the
Okay. Then this order came to be passed.
yes, my lord.
6/9. This is more than the
Amount
show
in the
cause notice.
yes, my lord. This was
Figures have gone high.
high,
Then page 30,
my lord.
what they have dropped?
And they have enhanced the amount, my lord.
No. Discussion and finding.
My lord.
It says after giving opportunity of being heard.
My lord.
Right.
My lord.
The records are reanalyzed and it is observed that. Then this one, 42 lakh something,
My lord.
proposed in DRC is not sustainable.
No sustainable.
So 42 is what? Nowhere mentioned in the DRC.
My lord.
Huh?
No, my lord.
DRC 01, where is 42? Where is that 42? Not sustainable. Demand amounting to 45 lakh CGST, same amount SGST. Found to be legally sustainable. On re-verification of records, additional computation as per provisions of so and so, so and so. So, show cause notice is for 84 lakh.
My lord.
That is DRC 01.
My lord.
Then no reply filed by the petitioner. Then no 75.4.
My lord.
And the amount has become, they have increased the amount.
My lord.
But what they have dropped or not sustainable, then what is more 45 lakh? What is this?
On this particular point, my lord, he has not even replied. So that cannot
One
be
is
yes.
not even reply, but 75.4 is still applicable.
My lord,
75.4 is still applicable.
lordship.
You cannot say
No,
that
no,
it
I'm
is
not
not
on that.
applicable.
No, for that, my lord, at least there should have been some reply, then he would have opted for hearing, but here, my lord, he is not even able.
No, you stop the thing in the very beginning, not applicable. Is it not? At the very beginning, you have nipped the bud. Page 23.
My lord.
NA means, I think, not applicable.
My lord. Yes.
Is it not?
Yes.
So, from the very beginning, you have, whereas it is a statutory mandate,
I understand, my lord.
then even if it does not file any
May I
reply,
read, my lord, 75.4 for a moment, my lord?
Huh?
75.4, may I read it, my lord? An opportunity of hearing shall be granted where a request is received in writing from the person chargeable with tax or penalty, or where any adverse decision is contemplated against such person.
both.
Where is the writing, my lord, from him? An opportunity shall be granted.
Where is the
request is received?
request?
He has not made any request, my lord.
Or
what?
or is there? Or where any adverse order and decision is contemplated against such person.
Yes, that
Or-
has been interpreted
Yes, my lord.
many times. Even if, I think, there are decisions also, even if he does not file any reply, but still,
If there is a contemplation, my lord, then.
any adverse order is going to be passed.
But my lord, there are 2 points, my lord. One is regarding, my lord, 73.1 notice. That part, it has been, my lord, here, it has been fulfilled. Page 24 is the, my lord, notice under 73.1. then DRC one. Thereafter attachment, only part that remains is yes, that hearing part.
75-4. First part of 75-4,
Yes, madam.
you said not applicable. So where is the question of request? And secondly, where any adverse decision is contemplated. I think that has been interpreted many times.
Yes, ma'am, it is there, ma'am.
You said not applicable.
Yes.
Let us see.
At least as a.
Paragraph 25, internal page 23, madam. Paragraph 25, 26, 27, 28, madam. 27 will be relevant, madam. 27, 28.
25, lordship may see 25.
There is another decision, Supreme Court or that whenever an adverse order is going to be passed, the second part,
My lord.
and there must be an opportunity of being heard.
Is there, not right now, but it is there. Lordship has actually pointed out, it is there, man. I have gone through it once, my lord.
Even if no reply is filed,
My lord.
but when the order is going to be adverse, there must be an opportunity of being heard. Personal hearing. Somewhere I have also
I will find out, my lord. I've read somewhere. Lordship.
referring to something. This is one part.
My lord.
Now, whether.
Now, second, no, what I have noticed,
Lordship.
the show cause notice is for a particular amount.
Madam.
Show cause notice is for a particular amount.
Madam.
1 crore, suppose.
Lordship.
Let us have a simple figure.
Madam.
1 crore. Then it must be confined to 1 crore. You cannot increase it to 1 crore 20. Then there has to be a separate show cause notice.
That is what your lordship has pointed out, was contemplated in section 75, subsection 7.
No, lordship will see page 23 for a moment, DRC 1.
Just a minute. Well, both so I cannot.
My lord, sorry, my lord.
Huh.
Page 22.
Yes,
start.
yes.
Lordship will see the figure, my lord, 84, 48, 134.68.
84, huh?
Yes. Then lordship will see page 24. That is the purported, my lord, notice under section 73.
Huh.
Then lordship will find
Page
page
25.
25 exact the same amount.
Huh.
It is there otherwise.
No, this order, see.
Yes, sir.
See that order. Page, say 27.
Lordship. Summary of the order.
Find out. I am not in a position to check all this.
But 28.
Turnover, it is okay. Turnover, it is okay. Same, right?
Well,
Turnover figure, I think, is same. Then you tax. Tax is okay.
Okay, ma'am.
Interest,
It has increased, ma'am.
you increased. Penalty, okay. First one. Next one. You see. Page 23. 3 crore something, 8 lakh, right? There are 2 rows. Page 23.
well,
Have you got it?
yes, yes.
There are 2 figures. Turnover. it is okay. Tax, okay.
Yes.
Interest, you changed,
18.
right, from 11 to 14. Penalty is okay. Now come to section 75(7). It includes
Interest also.
interest also. There are two statutory infirmities.
Apparent.
Well, these are apparent because I am not going to the facts, but
Lots
these
of
are
facts.
quite clear.
4 and 7, my lord.
4 and 7. That would, because to increase, you have to give a fresh suppose notice for them.
Lordship.
Or you have to issue an additional show cause notice perhaps.
Lordship.
But you cannot, suppose a disciplinary proceeding, suppose,
My lord.
as to why you should not be imposed a penalty of reducing, cutting two increments, suppose. You said, this is harsh. Then when the order came, dismissal.
My. Then
Can it be
aforesaid,
done?
Yes, that
So
aforesaid
that
will
is-
have to be given.
Tomorrow will pass.
My lord.
We'll post it tomorrow
My lord.
or Wednesday,
My
3
lord.
o'clock.
My
So
lord.
that 3 o'clock.
My lord.
It'll be available 3 o'clock.
My lord.
3 o'clock available.
Yes, yes, sir.
If anything there, you can submit, Mr.
I understand.
But these two are apparent on the face of the record.
Lordship.
It would, we may not interfere now. You have sufficient knowledge,
My lord. My lord.
sufficient knowledge about the liability.
Yes.
We may go back to the stage of show cause notice.
My lord. My lord.
Only show cause notice.
My lord.
Or if you want to withdraw it, you withdraw and issue a fresh show cause
My-
notice if the time limit is available with you.
Yes. Other
Or any time spent during this proceeding.
that will be protected, my lord.
Yes, ma'am.
Understand.
Right.
Lordship.
I think that will be better. Now you can issue a fresh show cause notice. If you want to impose more penalty, more interest, more
Including hearing now, my lord.
plus hearing.
Yes.
75(4), 75(7).
I will take up with that.
You take a call
That liberty is there, yes, my lord.
on at 3 p.m. I heard Mr. R.S. Mishra, learned counsel for the petitioner, and Mr. B. Govil, and standing counsel Finance and Taxation Department. For all the respondents, let the case be listed on Wednesday, and the case will be taken up at 3 p.m. The interim order past area shall continue till the next date of this. And it is within time or not?
Within time, my lord. Within time.
Repetition is within time.
Yes, within time, my lord. Within time. my lord. Within time.
Otherwise,
Yes, my lord. It is within time.
yes. What is the issue?
Lord, respondent number 4 to 6, they are more strangers. Their name have been recorded in the property belong to us.
You are in possession.
Yes.
Okay. I heard Mr. M.U. Mondal, learned counsel for the petitioner. Petitioner, huh? Hello. Mr. S.
Now, they
J&D.
suggest me that one thing, my lord. Despite the application to the circle officer and the my lord, first appeal to the DC, no action has been taken. Ultimately, we have filed second appeal before the my lord, commissioner. It is a public service declared notified. Now, that appeal is also pending. My lord. Page 33, if the that can be disposed of, my lord. Otherwise, private respondent is not also responding. My lord. They got the notice. They have not turned up. Page 33, my lord. It is statutory appeal. if the appeal is disposed of, directing the respondent authorities to dispose of the appeal after hearing the petitioner as well as the respondent.
Mr. Revenue, find out it is registered or not. Tomorrow they may come up that it is not received. You will be in trouble. Find out whether it is pending before you. Right? You get, and whether it is disposed of or not disposed of. Then we can dispose of the writ petition to consider and dispose of this appeal. First, you have to ascertain, because they have said that page 36, they have uploaded, or what?
Yes,
Page 36?
36.
Government uses Yahoo. Page 36. What is this? Page 36, what? That you have uploaded it.
Yes.
Huh? What you have said, let us see. Annexer 9.
9.
Annexer 9. Which paragraph? I don't know. They have uploaded in some Yahoo.
Some other. That it not be.
MSM Bhannan.
আপনার লাগে email
Is there any Bhannan? MSM Bhannan Yahoo.co.in? I don't think it will be gov.in
or nic.in.
I'll verify minute. Let
You
them
have sent to some individual perhaps.
Yes. Let them also verify minute. That has been, of course.
Not very specific. No step. Otherwise, if it is online, some acknowledgement must have been generated by the system.
They have
is
from
their
this they have sent it through email to some individual person.
We will also verify.
Lodge.
You filed your application for what service?
Cancellation of the name of the respondent number 4 to 6.
Before whom?
From the, or initially, the district commissioner Dubi.
Page?
Page 30.
This is not online. DC Dhubri, but this is a service for what? For correction of land record. This will be not part of the.
Assam portal APDC.
Not RDP. This will not come. You want deletion of the name of the private respondents.
Private respondent.
Your names are already there.
There.
So you want deletion. Then file your reply.
File reply.
ME Mondals for the petitioners. J. Hendrik Revenue 1, SS Roy 2 and 3. Mr. Hendrik, on the previous day you said you received essay instruction to.
Actually, what had happened, it was with H.K. Hazarika. He is hospitalized, so
Okay. Okay, you said because that you have received a necessary instruction to file a counter. Okay. Both Mr. Hendrik and Mr. Roy have submitted that they have sought for. How much time?
3 weeks.
3 weeks time to file the counter affidavit as as necessary instructions have already been received. Please the case on so and so.
Publish.
Item 35.
May I please, your Lordship will find the order dated 27/2026, my lord. Though this honorable court
You
allowed
file
me-
your reply.
It is ready, my lord. I will file within a week, my lord.
Okay, Mr. R. Sharma, learned counsel for the petitioner, has sought for further 1 week time to file the affidavit in reply to the affidavit in opposition for filed by the respondent number 3. Mr.
I am for 2 and 3.
J. Hendrik, learned state counsel for the respondent number 2 and 3 is in attendance. Okay. What is the case about?
My lord, after obtaining the, my lord, consent to establish, my lord, ready mix concrete, my lord, plant unit. The petitioner established and, my lord, installed the machineries, my lord. While, my lord, the pollution.
Which area?
My lord, it's
Jorhat.
Jorhat.
Titawar.
Nowadays, huh?
Titawar.
Nowadays area is very
Lordship.
sensitive. Lays the case on science. All these are coming up, right? In discussion. Stone Kasa.
Yes.
Okay.
11 September, 1109. Supplementary list, item 53.
Private respondents? What does it say?
You're saying trial magistrate,
Huh?
that is, this case, this case.
It is not maintainable in the present form. Liable to be dispatched. Who is the counsel? Mr. Safe. He used to be present till 4:30 normally. Hmm? Here is the contemplation that will dispose of this repetition. Not sure. Anyway, you are having interim order. Interim order?
Obliged, your lordship.
Okay. Mr. In Ajay, learned counsel for the petitioner. Mr. S.S. Roy, learned junior government advocate Assam for the, and Mr. S.S. Roy. For the respondent number 1 and 4 are present. The learned counsel for the respondent number 5 is found absent today on call, though their names are reflected in the cause list. Poster. The respondent number 5 has already filed an affidavit in opposition. You have not representation on behalf of the respondent number 5 today on call. Let the case come up for inch of justice, be listed again on next week of DD. An endeavor will be made on the next date of listing to dispose of the writ petition. The interim order passed shall continue till the next date of listing.
Obliged.
28th August, 2808.
Let it be on the first week of September.
প্রথম উইকট আপনি সেপ্টেম্বর
2nd September, das. Again,
Let it be on 2nd September.
2nd September.
Obliged.
Time being matter, item 27.
Yes, Lordship. I am sorry, my lord, at the time. I could not.
This is same thing. Panchayat.
Panchayat, my lord. Panchayat, what happened, my lord?
What happened?
Notification for election was declared. I, along with the private respondent, submitted our nomination papers. Subsequently, it was found that violation of the conditions precedent, that means the addendum contained 3 as well as 12, my lord. 3 says
child should not be married, means he should not be of child marriage. Secondly, educational qualification method. What happened, my lord?
But you are a contesting candidate, defeated candidate.
Defeated candidate. That is correct.
Have you filed any election petition?
No, my lord. I have not filed. What happened, my lord? As soon as I came to know, I filed one complaint before the authority concerned.
That may not be, scope may not be available to you. For you are not an elector. You are a contesting candidate.
But
We'll examine the matter because many difficulties have come up. Many difficulties, many complications have come up in these issues. At least for me. I'm still trying to understand what is the implication. Because you are not an elector. For you, it may not be available. We are examining the other issue, but so far as you are concerned, be on your guard. If you are a defeated candidate, you have to file an election petition.
Yes, my lord, my case was that I was the
You could have initiated a complaint through some stranger. That is a different issue. But you, being a contesting candidate, may not be. You could have initiated a complaint through your cousin.
Maybe.
Right. But that possibility of entertaining this writ petition may not be there. We'll examine the issue because many complications have come in the meantime.
Because in one of the cases, I have seen some special cases. Petition
No
is not-
special case. In election cases, no special case.
Already division bench also, my lord.
No, Mr. Don't make submission before this court.
Yes.
There are many
Yes.
complexities now.
Yes.
Division bench was prima facie
I also understand my prima
as a
facie-
defeated prima facie
I also understand my prima
as a
facie-
defeated candidate. You may not have a
good case.
You are in a slippery wicket. You are in a sticky wicket.
I understand.
We'll put it on the same date.
29th September. Yes.
2009. 2009.
2909.
2909. Okay. Mr. M.K. Mishra, Learned Counsel for the petitioner. And Mr. S.S. Roy, 1 and 3. H. Ahmed. Ali. 4, 5 are present. It is submitted that yes, Mr. Roy, file if you have filed.
I have also.
The respondent number 5 has already filed an affidavit in opposition, and the petitioner, in response to the state affidavit in opposition, has also filed an affidavit in reply. So stop. The state respondents have not filed any response till date. So stop. 3 weeks' time is granted to the state respondents to file the affidavit in opposition, lays the case on 29/9/2026.
I am sorry, at that time I could not reach my lord.
Supplementary list for orders, item 54.
Yes, why it has come? Mr. Chauhan?
I was directed to implead my lord the chief secretary. When
Okay.
Impleaded my lord 1-1
Impleaded when? I have seen some.
and filed the
I
court
have
title.
amended cost title.
My lord.
He is newly impleaded.
Yes, my lord.
1.1.
1.1.
So you accept notice? I heard Mr. S. Chauhan, Learned Counsel for the petitioner. And Mr. Roy?
Lordship.
All lordship. All. And Mr. S. Roy, Learned Junior Government Advocate Assam for the respondent number 1, 2, 3, and 4. 5, 6. Post of. The respond number 1.1 has been newly implemented by an order. It
My lord, notice already.
already is gone.
Regarding my lord, this.
Not there, not there.
Yes.
Not there. I have looked into.
Yes. What is
Uh,
that copy?
hmm. Has been subsequently implemented. Post of, therefore, a notice be issued to the newly implemented party respond number 1.1 post of returnable in 4 weeks. The notice is made returnable in 4 weeks as Mr. Roy, and junior government advocate who has appeared for all this, who is representing respond number 1 to 6. Has submitted that he will accept notice also on behalf of the newly implemented respond number 1.1. Post of. Mr. Roy,
Lordship.
you have to file affidavit.
Lordship.
It looks like
My lord,
Problem is,
the
lordship.
Court rejected my case. my lord,
Lordship,
although-
because
I have understood,
no
Mr.
extra copies were served to us on the last day, on the last occasion, day before, Friday, they have served. Only one copy have served.
Okay, tomorrow I say.
3 years.
All are rejected.
Again,
Again rejected.
all those,
All those.
they
On
are
same
coming
go.
now this time. We'll look into it.
Not all the,
No,
I have counted my.
I'm other cases. Other cases.
Not your case.
No, no.
Again,
Again, rejected.
cryptic,
They have taken, but rejection was on their earlier heinous crime. That's
they have not read perhaps.
most probably.
They do not want to read
This time they will again.
routine. This time I'll call for personal appearance. I'll ask whether he has read or not. Okay, the Mr. Chauhan shall furnish 3 copies of the writ petition along with annexer to Mr. Roy, Lanich Government Advocate, within 2 working days from today. The respondents shall file their affidavit, counter affidavits within 4 weeks' time. So start with the petitioner is seeking remission of his sentence on the ground that he has spent more than 23 years in custody. Right?
Right, my lord, and the police, my lord, reported in my favor, district police, SP and other.
No point. They will pass rejected, cryptic, heinous offense. That's all.